Welcome, welcome, welcome. And I really want to thank the people that's always, it's the same group that comes in here before I start every live stream. So I got to give y'all a shout out because y'all will come in and just start the chat and hang out and have a good time. So I thank everybody that comes through for the ones that were like, he didn't mention me, but you know who you are. You guys are always here and always waiting. And I appreciate that. So tonight we have two, we have two hearings. One is a landlord-tenant case where it's gonna get kind of wild, a lot of accusations and stuff going back and forth. And then there's a second case. We got an attorney that got himself in a little bit of heat. So we're gonna get right to it. And y'all know at the end I always have a special little song or something going on. So hello to everyone that's waving in the chat. I appreciate you. I just had to put that out there and never forget it. All right, so let's do it.
There you go. Anthony, can you unmute yourself?
Yes, sir. Can you hear us now?
Yes.
Yes, sir.
All right. And Ms. Deleuze, you've unmuted yourself.
I did. And Your Honor, I just wanted to say I did not submit any evidence. I did write something that I would like to read if I'm able.
As I'll explain, at some point I'll place you under oath, and if you want to do that, you can.
Thank you.
Okay.
Really? I thought they couldn't do it afterwards.
All right. All the parties are here for a small claims court trial. I wanted to explain how this will proceed, okay? First of all, I've received 3 packets of information. I'm going to go through those, and if anybody has any objection to any of the documents I've been provided, let me know. Otherwise, all of the documents I've been provided will be put into evidence and will be part of the evidence in this case. Second, we'll start with the Deleuze's, and whoever wants to testify first, I'll place under oath, and then they can testify. I'd like both parties to recognize I've read everything in your packets, so we don't necessarily have to repeat everything in there, just summarize what you believe this case is about. Okay?
Yes.
Once the Deleuze's are completed, then I'll place Ms. Rathi under oath if she wants to testify, and she can respond. And if Mr. Wakefield wants to testify, he can also. After Ms. Rathi presents her case, then the Deleuze's get a chance to respond. And part of that is because you're not sure what she's going to say, but also the Deleuze's have the burden of proof. And so in legal proceedings, you get the last say. And then I'll make a decision after that. Okay?
Sure.
All right. So this is a packet submitted by Defendant Rathi. And have you received this packet, Mr. Deleuze?
I've received the packet of all the court work, the paperwork, Your Honor. We've also, this morning, we were served by the Sheriff's Department. We have 10 days to vacate now. This all went on and was started well before we even knew what the result of this case was. So.
Okay. Right now, I'm just going to go through the documents. So the first one is a statement that says, Your Honor, and it's from Esther Rathi, and it basically addresses point by point all of the issues that the Deleuze's brought up. The second batch of documents appear to be the payment amounts that were paid to Mr. Deleuze. The third document is, it looks like a notice to vacate, and then that's followed by a 14-day notice to pay rent or vacate.
Yep.
And the fourth document is about 5 statements from folks that use the RV park. Okay. All right. Any objection to those?
I would object to any of those five if we're obviously allowed to address our accusers, because I think what happened was Esther got her little cronies and friends in the park to sign something, and they probably left their name out, because as far as we know, that would be a big campaign to get 5 signatures about people that honestly, they probably don't even know us, nor have they talked to us. But this is something out of spite that Esther likes to create.
Okay, so you can address that during your case.
Yes, sir.
After I place you under oath, okay?
Yes, sir. Show their names.
All right, the second packet I have is a multi-page, let me see if it's got the last page number on it.
Page 13, Your Honor.
13-page handwritten statement. I think it's from Mr. DeLuz, and that's followed by a calendar. Ms. Rothi, you've received that?
Yes,
Any objection to me considering that?
no,
All right. And then the last packet, I believe, is also from the DeLuzes, and it's a number of photographs.
Yep.
I'm just gonna flip forward.
Would you like me to summarize those, Your Honor?
Not now.
Okay. Okay.
So there's 28 photographs. And then there's something called document 2 and document 3. And then there's something called M1 and M2 and M3 and M4. Looks like M5, M6, M7, M8,
Yes, sir.
M9, and then E1, and that goes through E12, and then there's a D1.
Yes, sir.
Okay. You've received all those documents, Ms. Rothi,
yes.
and any objection to any of those?
Well, I don't know what they have to do with me giving them a notice to leave. And
Okay, we'll hear from them and see if they can make them relevant. Okay.
Okay.
All right. Thank you. All right. I'm going to admit all of the documents submitted by the parties in this case. So anytime you want to refer to a document that you've submitted or even that the other side submitted, just let me know. Okay. Who of the DeLuzes wants to testify first?
Am I able to read my statement as the last thing after the Rothies?
If you want to do it that way, that's fine. You have a chance to respond.
Sure, I'll do the response.
Okay. All right. Does that mean Mr. DeLuz wants to go first?
I could go through a road 13 pages if you'd like, Your Honor, or I can.
Okay, you're fading out, so make sure you keep your mic close to you.
I'm right here next to the window here trying to get a signal. Can you hear me, Your Honor?
Yes, I can.
Yes.
All
We
right.
just, in a synopsis in the 13 pages I wrote in the 6 years that we've lived here, I
Well,
just wanted to basically,
I got to place you under oath, sir.
I'm sorry.
Yeah, hold on for a second. Wolfpack is here. I try to wait a little bit in case people are filtering in, but thank you for coming. Hello, Mama Wolfie. I just seen you not long ago hanging out with you guys. So thanks for coming over here to hang out with us.
Great, that's fine.
Okay.
Yep.
If you raise your right hand, do you swear or affirm to tell the truth in these proceedings?
Absolutely, yes.
Okay. All right. So you're Anthony DeLuz?
Yes, sir.
All right. Go ahead and tell me what you want me to consider.
Well, I can tell you right off the bat, because Esther didn't gather 5 pieces of paper from somebody saying I'm this and that. She didn't do that before. She did that now that she knew the ratchet was up, and she's going to be on trial for how she treats people. She went ahead, and I can tell you right now, before even looking at the 5 statements, Your Honor, I can tell you right now what they are. Anthony's horrible. Anthony's mean to everybody. Anthony's this, Anthony's that. That's all she's got. I would absolutely object to any one of those, unless I would love it if they would give their names and come into the front of the camera and accuse me then. And I'll be honest with you, I probably won't see anybody do that, because all Esther has is 5 documents of hearsay, and that's that. That's that. She is so toxic. Jennifer hasn't even been here for almost a week. I'm assuming she's trying to shame us. We keep getting the same papers. We've got 3 times now. So she ties them on the door or something, and has people video her. Why she's doing it, I don't know why she's doing it, but she brought this up all along. This is Esther's
When you
mess.
say you're getting the same papers, what papers are those?
Oh, we're getting the same papers from the unlawful detainer, the same papers from a separate case that they filed and we got served on before this case was even heard today.
After our
Okay.
last court case, they filed a court case with us when they figured out. Yeah.
Okay, so that's when you got the 14-day notice?
After the last court date, yes, sir.
Okay, and it sounds like there was a hearing on that, and a order for a writ of restitution was issued?
Yes, sir. Yes,
Okay.
it was. Yes, sir.
And you've gotten notice from the sheriff that there's a move-out date?
About 3 hours ago, we got notice that we have to be out of here by Tuesday, the 24th, Your Honor.
Okay.
I want to see witnesses. I want to see them put their statement. I want to see their statement up close on video. That's what I'm aching to see.
Well, you've seen the witness statements, haven't you?
No, I haven't. No, sir.
Those weren't provided to you by Ms. Rothi?
I'm sure they were. We haven't been able to pick those up, Your Honor. We already know what they are. We didn't want to waste the $20 in round trip gas to look at them. We haven't been up there in a while. My health is failing. Jennifer's health is failing. That's why she's not even here, because it's such a toxic environment. But like I said, I would welcome any 5 or any 10 or any 20 that she can talk into saying something against me. But I would like that under oath and on video, because until that point, it's nothing but hearsay is all it is.
May I say something, Your Honor?
Not right now, Ms. Rothi.
Okay.
In fact, it might be wise if you just went ahead and muted yourself. So if you wanted to talk among the two of you, it doesn't come through, but we have to do this one at a time. Okay.
Well, Anthony got a lot of energy.
Thank you.
I would suggest you take notes so you know what to respond to. Mr. Deleuze, I'm interested in the part of your claim where you say that Ms. Rothi encouraged you not to take a job in Portland and work for the RV park.
Sure, that was it.
I can't hear you, so try to.
I'm sorry. Can you hear me, Your Honor?
Yes, now I can.
Yes, sir. There's several people here that are witness to that, especially my wife. I believe it was in October, Your Honor. In the construction business, we slow down. I've been a carpenter for 44 years. Over the winter, we slowed down. So in about the middle of October, Your Honor, I probably had 2 good lines. I wasn't hired yet, but I had two good leads on a couple contracting companies in Portland. But I had Esther come up to me at point blank. She says, "Anthony, if you quit looking for a job, I'll pay you $40 an hour. You can make." She made it sound like a dream Disneyland job. She said, "You can make your own hours. You can make your own schedule." And I said, "Wow, am I going to be able to get like at least 20, 30 hours a week?" And oh yeah, you can get 40. Long story short, I ended up getting probably the last couple of weeks. I think I got maybe 5, 6 hours a week. And then all of a sudden, one day out of nowhere, actually 1 week before Christmas that year, Your Honor, old Esther calls me up to the office, and for no rhyme or reason, she acted like a cowboy, and she goes, "We ain't partners no more." And the funny thing is, we never were partners, but that's how I got let go. No rhyme, no reason, no common sense, no respect, no nothing. Just, "We ain't partners no more." That's all she said. And I hope it's noted also, when she walked up to me, Your Honor, to give me the eviction notice, you know that she had the audacity to ask me point blank, and I'm going to quote her word for word, "If you admit to breaking the bathroom door, the assembly on that, I might rescind this eviction notice." When the funny thing is, I had absolutely nothing to do with that door. And that door, since we've been here, it's probably the third or fourth time it's busted. But Esther wanted to make sure that somehow I was blamed for that. And she's also told several people around the park. I'd love to get them here, but they're afraid for retaliation. So they don't want to testify. Because if you're not one of Esther's buddies, you're on the blacklist. And being a control freak, she will make sure that she retaliates against you. And she's retaliated against us from the moment they pulled the eviction notice. Because they pulled the eviction notice, Your Honor, because they were investigated by the state attorney general of Washington twice in a matter of 6 months.
Let's go to the slander
Sure.
claims. I guess one of them is she claimed that you broke the bathroom door when you say you didn't. What other statements are you claiming she told other tenants?
Oh, listen to this. Well, and boy, like I said, if I was able to subpoena and get people here and they wouldn't worry about retaliation, I've got a couple that's lived here and that's lived here for an awful long time that's told me that, oh, I think it was 5-6 months ago that somebody had defecated in the men's bathroom, and automatically Esther's going to say I did it. So for a fact, she told at least one of the couple in the park that I was the one shitting in the bathrooms, and she made sure that everybody knew, oh, don't worry, I'm going to boot them out. They're not going to be here long. She likes to play the control freak thing. So that's what happened with that. They told us point blank, Anthony, just so you know, we heard from another couple in here that Esther's saying that you're the one defecating in the bathrooms. And God, I find that hard to believe, being that I just don't understand where that comes from, because there's been people defecating in the bathrooms, and I actually provided some text messages in there between my wife and the lady that cleans here. That's been going on for years. So all of a sudden, since I filed the case against her, there's defecation in the bathroom. Guess whose fault it is?
Well, why are you thinking about that? See, now I paused it for a second. Mayor, thanks for the 5 gifted memberships. And those who received it, welcome to the trust. And thank you for hanging out tonight. Yeah, this guy, I see a lot of you saying he's moving too fast for you. So, well, he's talking faster than the judge, that's for sure.
It's automatically going to be me. Esther has a problem handling males with strong personalities. It's just a fact. There's nobody in here also. There's no tenants in here of color. Out of 52 spaces, there's not an Hispanic person. There's not an African American. There's not an Asian. There's nobody. Esther picks and chooses who lives here. If you talk bad against Esther, if you make a complaint, she'll just shut you up, or she'll tell you when you're going to pay your rent the next month, I can't take your money. That's what happens with Esther. She's judge, jury, and executioner. And she's been doing this and treating people like, you know what, garbage for about a little over 20 years now. Hopefully that's going to stop, because it's got to stop. I mean, there's so many people that have left this park already because of Esther.
Okay, so one of your claims that she slandered you, do you have a amount that you believe you should receive for the slander
Oh
claim?
God, Your Honor, the minimum would be $5,000, and the reason why, I'm a former general contractor of 20 years in the Oregon coast. I'm basically been trying, if it wasn't for depression, what about firing up a handyman business, or what about firing up anything? I live in a small town, and to go ahead and start my business license back up again, I don't know how many people that Esther has blabbed to this nonsense and this ridiculous false statements about what I did. It's really slander. And I don't know, would you want anybody doing a remodel in the interior of your home? Once again, something I've done for 44 years. If you believe all the stuff, all the venom that Esther spits. That's how it damages my, like I said, I've been self-employed. I'm 61 years old. I've been self-employed most of my life since I was 27. And that's kind of the road where I'm at right now. I haven't been picked up by any companies. Last time I worked, Your Honor, was October of last year. Starting up any small business to try to get back on my feet. I really don't know what my name is worth now, since Esther's basically had fun with it.
All right. You also claim that you were wrongfully terminated from the job that you had with the RV park.
That's the worst possible time. It's the week before Christmas.
And do you have a dollar amount for that?
Wow. Honestly, Your Honor, that would have to be another $5,000 minimum because it took me from getting let go in a job in March or April. So
He wants 10 grand, huh?
being that I usually average anywhere from $40 to $45 an hour, $5,000 wouldn't even cover it. But I'm assuming that's a small claim, so I'm gonna have to go with it.
Okay.
My patient's been ruined. She slandered me. She's done basically everything she could. I'd love to see him on video, and I'd love to see him under oath.
All right. Also, you're claiming that she wrongfully terminated your tenancy
sir.
at the park.
Yeah, and I'll tell you why. Her exact words were, "You make up your own schedule, you make up your own hours, you choose what you're going to do, what days you want to work." Blah blah blah.
No. I'm talking about your ability to stay at the park, not the job.
Oh, I'm sorry. I thought you were talking about being wrongfully terminated, Your Honor.
Yeah, you're claiming that she should not have been able to terminate your tenancy.
It also it's a big game that Esther created because first he hands us the eviction notice. He hands it to me. I was actually outside sitting in a lawn chair. He hands it to me the eviction notice. Says, "This is exact words. If you admit to breaking the bathroom door, I'll think about rescinding it." So that didn't have anything to do with the door. We got the notice a couple of weeks later when the attorney general asked more questions. She basically comes and goes that the attorney general pissed him off so much.
I'm not able to hear you, so you're gonna have to make some adjustments.
Can you hear me?
Yes, now I can.
Yes, sir. She basically rescinded the eviction notice, playing more games, going up and down about a month later after the attorney general broadened their investigation into Esther's handling of this park, because Esther basically stubbed her nose at the attorney general. And once she saw that they were asking for more information, they went ahead and decided to hand us back the eviction notice and say, okay, everything's okay. So it's been a mind, you know what? It's been a mind yo-yo with Esther from day one. So we're constantly there's a new camera now that's pointed right where we're at. So whenever we're outside, we're being watched. Months ago, Esther's came around the park and walking real slow. This is probably about 4 or 5 months ago, walking real slow as if she's trying to record me or something. She tries to be, I don't know, she tries to be macho and hardcore and intimidating and harassing. It doesn't work here, but I guess it's worked for with us 20 years because the other people we know here that we've known for 6 years, they don't want to say anything because they know if they do, they'll get Esther will come up with some excuse she makes up and they'll get evicted. That's why I can't get anybody to testify. Belmont Loop Park has probably got 5, 6, 7 or more tenants just from not wanting to deal with Esther. There's another mobile home park.
Okay. I went through what I believe your 3 claims are. Do you have any other claims other than the ones that I listed?
Other than sending sending my wife and I into a deep depression. That's all. I think I've said all I have to say. I'm just now, just want you to, whenever it's our last at bat, I just want my wife to say what she has to say.
Okay. Well, certainly give her that opportunity.
Yes, sir.
All right. Okay. Thank you, Mr. DeLuz.
Yes, sir.
It sounds like now we're going to turn over to Ms. Rothi. You want to unmute yourself there? Thank you.
Yes, Honor.
You want to raise your right hand, please? Do you swear or affirm to tell the truth in these proceedings?
Yes, sir.
Okay. And again, keeping in mind, I've read your materials. What would you like me to consider today?
Well, first off, I haven't badmouthed him at all. Those statements that was written about the park was how the park is run and how they like staying here. There's only one statement that was from Randy that Jennifer yelled at him. You mean you working for that blanking bitch? That's the only bad thing that was said about the Duluth. I don't talk to anybody about them. There's no needing to.
Mr. DeLuz, it might be good if you muted yourself during this testimony.
Yeah, I think I'm going to do that, Your Honor. I don't want to hear these false statements. So
yeah, I understand it's hard not to react, and so if you mute yourself, then that that's no problem.
I'll try to mute myself here, Your Honor.
All right. Okay, Ms. Rothi, go ahead.
Okay, so none of those statements was anything about him at all. They were statements about why they liked living in the park. And like I said, the only one that was about Jennifer was she screamed at him because he was going to be cleaning the bathrooms. I hired both of those. I hired Jennifer and Anthony to work in the park because they were having a hard time staying with their rent. They were always behind. Jennifer tried the bathrooms, and due to her illness, I had told her that she needed to take time off. And I text this. I asked her to come to the office, and she said that she wouldn't. And so I just texted her and told her because of her illness and all the stuff she was going through trying to get on disability, I was going to hire another person to start cleaning the bathrooms until she was capable of cleaning, and then she could come and talk to me again. As far as Anthony, there was no contract. I asked him if he wanted to work, which is a day labor type thing. There was he was not an employee. He put in his
Were
hours.
you aware that he was applying for construction jobs in Portland?
Well, that's what he said to me, but every 3 months he was without a job, give or take a couple of months. I don't know if he had a good paying job coming up. Why would he quit that and work for the park? The reason why I terminated our verbal agreement was he did not want to do the winterizing that needed to be done in the park. And he cut his own hours back to 5 hours that last week. I was willing to pay whatever hours he needed because there's a lot of maintenance to do in the wintertime. What he said to me was, you need to get me a big job so I can work on it. And so I said, fine. At first, I wanted some shelving done underneath in our storage area.
What did you understand a big job to be?
Something that he could put hours in and not have to do minor little things. And in the RV park, it has to do with maintenance. Winterized maintenance is not big jobs. It's one whole big job, but there you do this a little bit and this a little bit. And the person that I hired after Anthony within a week and a half, his name is Doug. He went in, started doing everything, and he did anywhere from 12 to 15 hours a week. And Anthony could have been doing that.
Okay.
The other thing is he talked about me defaming his character. I've spent the last 30 minutes of him saying nothing but taken my character down, that I've been in this park working here for 31 years. I have people that come in and out of the park. And the reason why he was given a 30-day notice is because I was unaware that the legislation of 2025 March, that they took us as RV parks out of hotel motel area and stuck us in with landlord tenants. And so with landlord tenants, I had to actually evict. I did not evict them. I gave them a 30-day notice to leave the park due to all the complaints that they complained about everybody, no matter who I had. And if you looked at the pictures, they are the area where they're at is very close together because we use them as dailies in and out. So
Why did you withdraw that notice to vacate?
say that again, please.
There was a
I did-
letter from
I withdrew it. I understood what you said now. I'm sorry.
yeah.
I withdrew it. We went and talked to an attorney, and he told me because we couldn't do a 30-day notice like we used to do, he told me I had to withdraw that.
Okay.
Yes, you heard deflame and legislation or whatever it was.
That was an advice of the attorney.
Okay.
Oh, and the other thing he was saying about all this double stuff that he was getting, well, they had a post office box and mail. They got mail at their post office box and mail at our park. And so our attorney mailed stuff to them at 2 different locations so they could get it. When they was no longer able to keep their post office box, everything was sent over to the office. And I took it down to them. That not all of it came at the same time. That was the reason why. The first one had 6 months of mail that they wouldn't come to the office and pick it up, and I don't deliver. I have people can get mail there for convenience. They don't have to go to the post office. They can just get their packages and everything right at the office. She refused to do it. She sent me a text and said no, with the hostile environment of the office, she was not going to come up and get it. I could forward it to her post office. Well, I didn't do that, and I'm not required to do that.
All right, anything further that you'd like me to consider?
Oh, I think he called me a racist because I didn't take blacks and
Minorities.
minorities.
Ma'am, that's
And
not
that-
a claim in this case. I
Well,
don't,
it's not a true statement. I've had black people in my park. I've had a Vietnamese person just left. I have his ex-wife in here. She's Vietnamese.
Huh?
As long as people can pay the rent, follow the rules, I really don't care what color or creed or religious they are.
all right, anything further?
Yeah, Marv Wakefield.
Yeah, I'd like to make a statement.
Okay, I need to place you under
Okay.
oath, sir.
Yes,
Do you swear or affirm to tell the truth in these proceedings?
I do.
All right, state your name, please, for the record.
Marvin Wakefield.
And what is your relation to this RV park?
I'm the co-owner of the RV park.
Okay, go ahead, sir. You
Okay,
can make your
yeah,
statement.
just briefly, maybe you know this or it's been mentioned before, but Esther's been the manager here for 31 out of the 32 years we've been in existence. We have many people that have been here long-term, longer than the Deluzes, and we've never forced anybody to stay if they didn't like it. But there are rules that need to be followed. But I want to get down to, I know that Esther never encouraged Anthony to quit a job somewhere else. He mentioned that. That's not true, is it?
No, it is
No.
not true.
Okay, and Mr. Deleuze talked about Esther coming over, bothering them, taping things on their door. Well, those were notices. We did not give him an eviction notice. He's at least 5 months behind in rent, over $5,000, and our lawyer did all the eviction. We placed a notice on the door, like is required of a landlord, and mailed him the information. But evidently, when he started the small claim court proceedings, he felt like he never had to pay rent again. And we did this out of, you've got to start it sometime. And so that's why it was done. And he does have to be out in a certain time. But the eviction came through from the lawyer, not from us.
That's why he wanted $5,000. You know, he can be able to stay back in the place.
Okay.
And Esther's information was not about him or what kind of a person he was. It was just about Esther and what kind of a person other people say that she has been in the park. And we had to go through a zone change not long ago. Esther was instrumental in getting that done with the city. She had a lot of praise from people in the city, and
Including Jennifer.
including Jennifer, that backed us for that zone change that we needed so everybody could stay as a long-term basis. And I think this is absolutely just any reason he can come up with to try to make $5,000 or whatever he can. But, you know, if he's talking about Esther's character, what about his character in not being upfront and saying, hey, we can't afford, excuse me, can't afford to live here anymore and we'll move on. But I don't know how long he would have hung on. But most landlords give them the 14, you know, they'll wait 14 days and start a notice right away. This is 5 months, another about 6 months now.
Yeah.
So it's probably more money, probably
Okay.
$6,000 now.
Today.
So that's where we're at.
All right, thank you.
Mhm.
All right, Ms. Deleuze, you wanted to read something as a rebuttal, and Ms. Rothie, I would encourage you to mute your microphone at this time. All right, Ms. Deleuze, you may go forward. Oh, yep, excuse me, thanks for reminding me. Do you swear or affirm to tell the truth in these proceedings?
I do.
All right, thank you.
Okay, before
Yeah.
I read what I'd like to read, can I address a couple of things that they had mentioned?
You may. It's your turn to speak.
Thank you. First off, I would just like to address, yes, I absolutely did speak on behalf of the park in May 2024. On behalf of the zone change, I spoke in support of Esther and the park. After that, the word around the park was that I saved the park. I'm pretty good at writing. I'm good at speaking. I was very happy that the park got the zone change because so many of us live there long term. About the bathrooms, I had been cleaning the bathrooms on the weekend for about 1.5 years, just a couple hours. I never asked to have my hours reduced. The other lady who cleans during the week, she had missed weeks at a time, bad back, she had a fall. There was never any issue with her missing a week at a time, a couple different times. She never got fired, never got in trouble. Well, after 1.5 years, one weekend I was sick, and it was the weekend before she decided to do the eviction. So 2 days after the weekend, I was sick. And on Friday, Saturday, and Sunday, I texted Esther all 3 of those days and said, hey, I'm really sick. I'm not going to be able to clean. Well, on Sunday, she asked if I would come up and talk. And I said, no, I'm really sick. I don't want to get you guys sick, and I'm just not feeling up to it. She also asked on Monday. I was still sick. I also had a Zoom doctor's appointment. I was not able to go up. Hindsight being 2020, I know that Esther took that as probably some type of disrespect, and that probably helped to perpetuate a feeling of loss of control. And that's another reason she decided to just evict us. After she rescinded the first eviction, she never made any attempt to talk with me, even though I had requested, let's talk. I would love to have my cleaning job back, because that was a significant reduction in rent. And just a couple hours a day, that was something I was able to do. In the 1.5 years, I had only missed just a couple times of doing it. One thing that I bet the owner isn't aware of was that Randy, who I never yelled at, maybe I talk loud, but Randy cleaned for 1 week. After the first week, Randy was caught in the women's bathroom with his pants down by another woman in the park. So nobody has been cleaning the bathrooms in the park on the weekends for about 5 months. Nobody's cleaning on the weekends. We get dirty bathrooms. So I hope the owner realizes that. Nobody's cleaning on the weekends. We get dirty bathrooms.
All right, let me stop her real quick. Trish, thank you for the super chat. And she has a message. She said she'll buy 5 memberships if they get up to 60 likes. So y'all can handle that with Trish. But appreciate it, Trish. Thank you very much.
About Anthony's employment, actually Esther asked me specifically, I believe I might even have a text. She asked me specifically if she offered Anthony a full-time job, if he would quit looking for other work. She said she had other projects that needed to be done, big projects, even like building cabinets and shelves down below where all the tools were. Those never came to fruition. One of the reasons she was happy to offer Anthony a job was because then he would be closer to home and able to help take care of me. I did ask her to forward mail, because at 44 years old, the last thing I want to do is get into some yelling or screaming match with, I don't know if she's 80, 79. I'm not sure how old she is, but I had just had enough experience with her behavior and mental health that I wasn't going to put myself in this situation to be up in her office and get into some kind of match with her. So that's just kind of all I wanted to talk about with the things that she had just mentioned. Those things didn't sit right with me. If you would let me proceed, I would love to just read a couple things that I had written.
Please.
Closing statement.
Before you get into that, I'm not sure what kind of trailer park this is. I don't know if it's one for visitors and they have people there. Because when she mentioned the bathrooms, it sounded like a community bathroom. So I don't know. I never heard of that before.
Okay, Your Honor, my first instinct was to speak on everything I've seen and heard Esther do as the manager of Woodland Shores RV Park. I could have easily wrote 20 pages on the injustices, illegal evictions, and vicious ways she talks about residents in the park. However, I am aware of the documents my husband submitted, and I'd like you to know that I've never seen him write more than a paragraph at a time. So I ask and hope that as you sifted through all the evidence, that you could see a man and a couple that has been dragged through the mud by Esther. She has treated my husband specifically bad, lied to him, on him, picked on him, bullied and targeted him, and tried to threaten, harass, and intimidate the both of us since September. In an effort to keep it short, Your Honor, we are here because Esther Rothy blamed my husband for normal wear and tear on a bathroom door bracket. Her own video shows my husband walking in and out like normal. She told me when I asked her that day that if Anthony had admitted to breaking the door, she wouldn't have evicted us. For the past 7 years, I have been Esther's friend and have heard her make statements like, nothing makes it to the owners except what I want to. And the owners always believe me and choose my side. In 7 years, I've seen her target, bully, and wrongfully evict long-term tenants from the park based on her own bad mood and dislike for the residents. I never thought she would turn on us or me, and I'm so sorry and embarrassed that I didn't stand up for her friends and neighbors sooner. And it's true. Most residents and myself stayed quiet out of fear of retaliation. September 11th was a normal day. My husband was trimming his tomatoes and I was preparing to wave signs for city council and school board candidates. Rent wasn't due for another week. We were caught up, and so we were just living our lives. That morning on September 11th, Esther single-handedly uprooted and caused undue stress and chaos in our life. You can reference her own eviction paperwork where she states the reason for our eviction as, you need to move on as it doesn't sound like you two like being in the park. The truth is that when we moved in 2019, the park was quiet, clean, and strict with generally no dogs or kids allowed. That all changed during COVID. And the space to the east of us became a rotating door for drunks or people that had multiple aggressive and reactive dogs that were alone and barking nonstop for 10 to 16 hours a day. Esther expects neighbors to just deal with it and only acts after these dogs nip and lunge at multiple people. Esther and the owners would like you to believe they've done nothing wrong. And I'd like to point out an email from Esther to the Attorney General of Washington State. Yes, I did reach out to the Attorney General, as many former residents have done in the past. We're on record, and you do have that email in your evidence. She lies about me, stating that I lied to the Attorney General that I live in a mobile home. In short, the Attorney General took my case and proceeded to send 3 emails to Woodland Shores and the owners asking for each RV site, how long the residents have lived there, and if it is their primary home. The Attorney General agrees that our long-term status gives us certain protections, and we are unable to be evicted because someone is angry and going through a manic bipolar episode. Basically, we do deserve protections. Esther proceeded to tell the Attorney General of Washington State that he was wrong and she was right, as she's been running the park for 29 years, and you can see that in her email. Fast forward to November 6th. I have now won my election. Yes, I had to deal with Esther's manufactured scenario during one of the most important times of my life. The same day that I won, Esther and Woodland Shores receive a final email from the Attorney General stating that if they do not comply and send the requested info, then the Attorney General is going to expand program services to us and initiate a full investigation into the park. The next day, in an aggressive and hostile manner, Esther knocked on our door, handed me another unofficial paper that said they were rescinding the eviction, and she did this in silence with a phone recording in my face. The last words I spoke with Esther was asking to pay our rent. She declined to give my job back. She refused to forward our mail for 5 months. After rescinding the eviction, the harassment, intimidation, hostility, defamation of character continued against both of us, but especially against Anthony. No reconciliation was ever attempted. Anytime my husband was outside, there was Esther lurking with her phone, filming my husband. Someone made a mess in the bathroom. She told everyone it was Anthony, even though as someone who cleaned the bathroom for a year and a half, I seen that it had been a problem behavior, and she never tried to find out who was doing it. This entire time, Esther has curated a hostile and angry environment. Your Honor, I guess my point is we shouldn't be here. None of this should have happened. Esther essentially pulled a pin on a grenade, threw it into our RV site like she's done to so many people before, and thought she was going to sit back and watch us scramble, tuck tail, and run. Well, she picked the wrong people, and I should have stood up for the people she's done this to before. Maybe she got angry with me because October of 2024, she asked me to write a letter of support for her because a resident in the park had also turned her in to the Attorney General. For whatever reason, I did not write that letter. Later, in early 2025, I believe, I might be wrong on that date, she asked if I could be a reference for her as she was applying to be on the LTAC committee with the city. Again, for whatever reason, I did not participate. At 44 and 61 years old, my husband and I decided to fight back against a manager and distant and disengaged owners who are getting away with things they should not. I should be enjoying and learning all the things that come along with my new position. And instead, I'm dealing with the fallout from a manufactured situation that stems from someone's mental instability. Even now, I'm confident that the owners are in the dark to 70% of the truth of this situation, the truth about Esther, and how the entire community truly feels about her. I hope you were still connected to the meeting at the last court date, because before the owners and Esther disconnected on their end, one of the owners said, "Should I flip them off now?" and flip the camera off. Your Honor, I ask that you hold Woodland Shores accountable for the situation they created, perpetuated, and continue to sustain an irreconcilable and hostile environment to this day. We were not thinking of moving. It's expensive to move. We want to move, but they created this whole thing. I'm asking that you please enforce a pay to play on them so that they respect their residents in the future. Many who are elderly or like us have an older RV that isn't easily accepted into other parks. Woodland Shores has been getting away with bullying, lying, and contributing to homelessness for as long as Esther Rothy has been a manager. The harassment and intimidation has continued so much that, she did hang many copies on our doors with zip ties. I kind of felt like that was an act of shame. We don't need 6 copies of the same thing. So finally, for peace of mind, I did have to leave, separated from the man I love and who takes care of me, because not a single day has passed without some form of hate, harassment, retaliation, or intimidation. Please make a statement today and rule in our favor that this type of behavior is unacceptable and no longer tolerated. Thank you, Your Honor.
Sound like she just read a letter from graduating to school for the top of her class.
All right, thank you.
Your Honor, am I able to say anything to that?
No, actually, the plaintiffs get the last word. So if I'm going to cut off testimony at this point.
Okay. It was just a comment about the bathroom.
All right. Thank you both. I want to pull up the small claims claim.
But I can agree. If they had that much trouble, even since COVID, why are they still there?
So on the small claims claim, it says there's wrongful eviction, wrongful termination, and they're claiming $5,000 in moving costs, and the claim is for $5,000. Okay. The claim expanded a little bit, and I to some extent allowed it. to also include allegations of slander, allegations that there was a wrongful termination from the job at the RV park, that there was a wrongful eviction, we'll call it, and then because both sides addressed it, there was a allegation of racism. So those are the four things that I'm going to address in my decision. Okay. It appeared to me that there certainly was some, and maybe better said, a lot of tension in the relationship between the DeLuzes and Ms. Rothi. And I'm in listening to the testimony, probably both parties have something to contribute to that. My decision today, though, has to be based not just on what was the dynamic of the relationship. I don't think that's an actionable cause of action, that we didn't get along or we had disputes. I don't think you get compensated for that. I have to base my decision on what the law is. So when we go to the slander claim, Mr. DeLuz claims $5,000 because he feels that the slanders affected his ability to obtain employment. And what does not exist is there's no evidence that a particular job was affected. So even if I accept that Ms. Rothi said things about him that impugned his ability to work or be a general contractor or be a carpenter, there's no evidence that there's a specific job that was affected or that there was a lost job. So as to that claim, I'm finding in the defendant's favor. The second one is that he was terminated from the job that he had at the RV park. And clearly there was some offer to hire him to do a number of things around the park. I will just parenthetically say that some of the inconsistencies in this case is that even though right from the beginning the DeLuzes claimed there was tension with Ms. Rothi, then there is Mr. DeLuz accepting employment with the park under Ms. Rothi. Also, there's Ms. DeLuz going to city council to argue on behalf of the park and apparently say positive things on behalf of Ms. Rothi. But be that as it may, with those inconsistencies, there was no employment agreement, and so employment in the state of Washington under the situation that occurred here is what we call employment at will. And employment at will can be terminated at any time for any reason, unless it's something that violates the Constitution or is something actionable in that way. But that's not what happened here. I think Ms. Rothi either made a determination that Mr. DeLuz didn't want to work as much, or just decided that it wasn't working out. And in that situation, where your employment is at will, you can be terminated. So under the claim that he was wrongfully terminated from the job, I'm going to find in favor of the defendant. Similarly, to the extent that Ms. DeLuz believes that she should have been hired back and wasn't, that employment is also at will. So I find no claim there. The third claim is that they were wrongfully evicted, and there was this notice of eviction that went back and forth, I guess, with the Attorney General and then was eventually withdrawn. So at that point, they were given a number of notices of that. They had to address it, but they were not evicted because of that. What happened afterward is there was a 14-day notice, which was proper in this setting, to pay rent or vacate. And apparently the rent was not paid. That went through the Cowlitz County Superior Court's unlawful detainer docket. If there was a claim of that eviction was unlawful, that would have been the place to present that evidence. Apparently, if it was presented, the court still issued an order for the writ, and that writ has now been served on the Deluzes, and they're to be out, I guess, by about 2 weeks from now. So in terms of a wrongful eviction, I find that the park went through the proper eviction procedure by giving a 14-day notice. It went to court. The Deluzes had a chance to address their issues there, and the court still issued the order. So I don't find that there was a wrongful eviction. And then finally, there was this claim about racism, and both sides felt compelled to address it. That was not a claim brought in the initial small claims case. I don't, it's not something I intend to address here. So when we put all this together, I am sensitive to the fact that the relationship was fraught between everyone. And again, as I said, probably both sides contributed to that. But in terms of evaluating these claims under a legal standard, I'm going to find in the defendant's favor.
Anthony left the building.
All right. Thank you all. You're free to leave. I will fill out the judgment, and I think the court will send it to you.
Thank you, Your Honor.
In the next few days. Okay.
Thank you.
All right. Thank you.
See, we had the guy that talked too fast, and now people complain that the judge is talking too slow. I thought you'd be happy that it slowed down a little bit, but I guess you said it was too much. So as you see here, the vanishing attorney. So we got 600,000 errors in the disappearing act. You can't be an attorney and leave your job, especially if you leave the courthouse. So let's go on and check this thing out real quick. All right, let's go.
Good morning, counsel. Good morning, Ms. Fleming. Good morning, Mr. Campbell. Before we start today, I wanted to ask if counsel has had an opportunity to discuss any potential resolution of this matter, and if you'd like some time to conduct further discussions.
Beyond the filing of my motion, which I believe is pending on the motion for summary disposition, we've not, but obviously I think we're both interested in having that decided, and we can go from there.
Okay, Ms. Fleming, that is correct.
I would concur in that as well.
Okay, all right. So I will begin my chairperson statement, and we will proceed with the hearing. So this.
Oh, real quick, the attorney's not there. He already had like the pre-hearing. I can't think of it right now, but he had that hearing already. and now that guy's there is representing them. But you're gonna know everything that's going on. I don't know why he's not there today, and we'll just follow it from here.
Proceeding is both a hearing on a pending motion for summary disposition and a pre-hearing conference pursuant to MCR 9.115 F4C being held via Zoom video conferencing before Tri-County Hearing Panel number 16 of the Michigan Attorney Discipline Board in the matter of grievance administrator versus Maurice Cortez Davis, P 76203, case number 25-90-GA. The panel is comprised of Anthea E. Papista, chairperson, Howard E. Gerwin, member, and Saida Farhana Davidson, member. This panel has been appointed by the Attorney Discipline Board, the adjudicative arm of the Michigan Supreme Court, for the discharge of its constitutional responsibility to supervise and discipline Michigan attorneys. Counsel for the grievance administrator is Caitlin O. Fleming, who will present the case for the Attorney Grievance Commission, a separate branch of the Michigan Supreme Court for the investigation and prosecution of discipline matters. Counsel for respondent are Donald D. Campbell and James J. Hunter. Counsel, please put your appearances on the record.
You, Caitlin Fleming, on behalf of the grievance administrator.
Donald Campbell on behalf of Maurice Davis.
Thank you, counsel. Mr. Campbell, would you like to proceed?
Yes. So you have our briefing on this. Largely, I'm going to rest on the briefing. Count one deals with really two instances that they claim constitute a basis to make the charges. The first is a failure to appear at a pre-trial matter. As it turns out, again, just regular scheduling issues in terms of why my client wasn't there, nothing extraordinary. What happened was the judge then forced my client's client into a situation where he had to make an election on whether he wanted a trial or not, as opposed to seeking a plea, apparently. Subsequently, when the case is all done, the Court of Appeals says it's the judge who acted wrongly in proceeding without my client or counsel being present for the defendant, Mr. Miller. So that's not my client's issue or dealing. Again, this is regular, he tried to, in fact, I think he even contacted the prosecutor prior to the event to say, hey, there's some issue with showing up. It's in the brief, all the materials regarding that. The second issue they have is that my client left after jury selection. Again, there were two lawyers there to represent the defendant at the time, Mr. Miller. My client was one of the two. Both had separate appearances. The second lawyer conducted the case, did so admirably, capably, without any difficulties. Certain portions of the charges were dismissed by the jury. Certain findings were made of guilt at that time. Of course, that's what got overturned by the Court of Appeals, and the case was remanded back. The judge was not happy about my client, the trial judge, about my client leaving without saying that he was leaving. Again, no rule cited by anybody, either the trial court or the Court of Appeals, with regard to my client's etiquette in the manner in which he left. All
right, real quick, Trish, 5 gifted memberships. Appreciate that, Trish, and the ones who received it, welcome to the trust, and thanks for hanging out.
He was ordered to return. He returned. The trial was not held up because of it. We're talking minutes out of a day or whatever. He came in, he was there for the whole proceeding, sat through it unnecessarily, frankly, because the other lawyer did the entire case. He didn't need to be there, but because he was ordered to be there, he was there. There's no professional misconduct at all in any of that. So, and that's count one. Count two, you have the mailing, basically an advertisement. And my client uses an agency for that purpose. Not unusual in his sphere of practice. I think I gave you the number at the time. It was close to 600,000 mailings. And this is the only error that anybody's ever pointed out. And the error was a simple scrivener's error on behalf of the advertiser, as opposed to including a paren A at the end. It was not included. It ended up being a criminal charge versus a civil infraction. And also, as explained in the affidavit on the C-10 motion, by the provider. They have a policy of not sending those advertisements to minors. Here, it happened that their system didn't catch the birth date of the person involved. To me, what's most shocking is that person's parent, at least his dad, according to the request for investigation, is a lawyer.
All right, real quick. Julie, thanks for the 5 gifted memberships. We have 5 more people in the trust. This is a beautiful night. Welcome.
And he didn't understand the rules well enough to understand that my client didn't do anything wrong there. But we've laid it out for you with the affidavits and everything else. There's no basis for either count 1 or count 2. And to be honest, the best argument that I've been able to distill, if you will, from the response is, well, hey, summary disposition's disfavored. Well, no, in Feiger, it was disfavored in 1997. Since then, it has been the subject of a number of cases. And while there isn't a case that we can point to in the history of the Gray decision, counsel, I both provided you the case law. She goes to the Bruce, I forget Bruce's last name off the top of my head, decision, but Carrie Gray comes afterwards and clarifies that earlier decision. And in Carrie Gray, which has been followed, I gave you 2 cases in 2025 alone, where at the board level, they instructed everybody, that's for respondents counsel and the AGC included, everybody on how it is that you should take a look at cases where you're alleging that there is this failure to do something either under 1.4 or 1.3. And we've provided that case law to you. It should be followed. It is precedential. And I'd ask that both counts 1 and count 2 be dismissed.
Thank you. Ms. Fleming?
Thank you. I would just like to circle back, and I think it's important to circle back to the standards under MCR 2.116 C8 and C10. The question really before the hearing panel is, does the complaint state a claim upon which relief can be granted? And the grievance administrator submits that under count 1 and count 2, both counts state claims upon which relief can be granted under the rules. With regard to count 1, counsel is correct. We do cite to grievance administrator v. Sage, which is 96-35-GA. And it's particularly cautionary because the hearing panel granted summary disposition in that case, and the board reversed and remanded the matter. And in doing so, pointed out that alleged violations of RPC 1.1 and 1.3 are fact-specific inquiries and are really going to turn on those facts and circumstances. What is reasonable and competent under all of the circumstances? In this particular case, in count 1, according to the facts alleged in the complaint, respondent filed his appearance on September 12th of 2023. About 20 days later, there's a plea hearing. He fails to appear. And as the Court of Appeals opinion points out, this was a critical hearing. This was an opportunity for negotiations to occur. He was not the original counsel on the matter, but filed his appearance about 20 days prior to the hearing. He then files a motion to withdraw shortly thereafter, which is denied on the date of the trial. Despite the denial, after jury selection, he leaves the courthouse. In count 2, again, based upon the pleadings alone, respondent used a direct mailing service to send MG a letter which indicates that he was facing a criminal offense and potential criminal consequences, which was false. He was facing a traffic citation. And MG was a minor and received this, and it's the grievance administrator's position that this was false and misleading solicitation and advertising. And there are likewise genuine issues of material fact, which the grievance administrator submits. The respondent indicates in the briefing that there are issues of fact, which should in and of itself defeat the motion under MCR 2.116 C10. in count one, respondent argues about when the obligation to remain present occurs. His position is that it occurs when the court ordered him to stay after he left. The position is different of the grievance administrator, where he filed his appearance. His motion was denied. He had an obligation and responsibility to stay at the hearing. With respect to count two, respondent raises a number of issues and questions of fact relative to respondents' oversight and responsibility relative to the content of the advertisement. He also raises whether the content of the targeted mailer is false or misleading itself, and whether the disclaimer at the bottom in small type absolves him of all of the content within that letter that was sent to MG. It's the grievance administrator's position that these issues are best resolved. And for that reason, the grievance administrator would request that, pursuant to the arguments today in the brief that was previously filed, that respondent's motion for summary disposition be.
I'm sorry, Caitlin, I did not hear the last 15 seconds.
Me
Oh,
too.
I'm sorry.
You
I'm
did.
not sure what. I think I was simply concluding that it's the grievance administrator's position that these issues are best resolved through a misconduct hearing. And for that reason, the request is that, pursuant to the argument today and the brief previously filed, that respondent's motion for summary disposition be denied, that the hearing panel set a deadline for respondent's answer to the complaint, and that the matter subsequently be set for a misconduct hearing. Thank you.
Okay, thank you. You both wrote excellent briefs. I might.
I do have very brief rebuttal, if I may, Madam Chair.
Yes, go ahead, Mr.
Thank you. And very briefly, the AGC ignores the disclosure at the bottom that says, hey, that you might not be the right person. You might not even be charged with anything. This may have reached you in error. There might be an error even within the letter. All of that, the disclaimer at the bottom of that letter, you have to read the letter as a whole. And you can't say, well, I'm just going to read the front part of this letter and not the bottom. And so I don't really understand how you can say that there's a false statement at all, because the letter itself contains the disclaimer. In addition, I really actually, as pointed out in our briefing very briefly, they can't say that my client sent this. And certainly he didn't know it was false, because he didn't know the contents of this letter when it was sent. That's just not the way the advertising works, as we've described in the attachments in terms of the affidavits. So they can't even prove that. There's no basis of proof. So it isn't, hey, we've stated a claim, so it's good. No. You have to state a valid claim. And where there's no valid claim, and looking at count 1 under C8 and count 2 under C10, there's no valid claim to either. Thank you.
Ms. Fleming, do you have anything further?
I would just state that relative to the advertisement, Mr. Campbell's arguing essentially that MG had a bigger obligation to review an advertisement that he didn't ask for. It was sent to him. He was targeted. He was targeted by a mailing service. And I guess the position relative to that would be that Mr. Campbell's client, respondent, has an obligation to be looking at the content of it and ensuring that it's not false and misleading. Yes, he's using a direct mailing service, but it appears as though he's using it and attempting to move away from the content of an advertisement that bears his signature, that has his firm name, that has his firm's address and information. And so that would be the argument with respect to the letter.
I have a question on with respect to the letter. What guidance do we have, either the grievance commission or from any of our courts here in Michigan, with respect to Shapiro, with respect to the Shapiro case? I don't like the letters. I'll tell you truthfully. Doesn't mean necessarily that there's an ethical violation. I really don't like these letters. But what guidance do we have from there?
Who do you want to take that first, Mr. Gerwin?
I'm sorry. Why don't we go, Mr. Campbell?
Okay. Well, so our rule 7.3 is our rule pre-Shapiro.
Right.
And all our court did is add the line, nothing in this rule above it is meant to be read in derivation of Shapiro. Almost everything above it is in derivation of Shapiro. In fact, it's a wonderful rule that prevents telegraphs. It doesn't say anything about emails, doesn't say anything about text messages. And to the extent it says letters, again, it has to be read in connection with Shapiro. Shapiro was a direct mail targeted advertisement. It was somebody who had a list of folks who had their homes in foreclosures.
Right. And
the letter said, hey, your home is in foreclosure. And I'll bet dollars to donuts, never having read the letter, what it said is, your home is in foreclosure, you need a lawyer. And at the very bottom, I'm sure it had a disclaimer that said, hey, read it carefully, because if you're not the person, if your home's not in foreclosure, it doesn't apply. But at least the outline of the letter was a targeted directed mail. And the Bar Association in Kentucky took the position, again, it's 1987 when the
way back,
88 when the U.S. Supreme Court decides it. So this would have been the early 80s, takes the position that you can't target mail to people who are known to need legal services. And that's basically what our Rule 7.3 says. But it doesn't apply because of Shapiro. And Shapiro is well settled law. Again, what is it? They're talking, it was 37 years since the last Michigan championship. Well, this is at least 5 years before that. So we're talking 40 plus years that Shapiro's been in place. And when you look at, I guess, one of the things I would say is, where's the Michigan case law that suggests that there's anything that comes even close to being actionable here? It is surprising. I had a case involving somebody making a contact in relation to an adoption. It never, I don't think it got to the board level. So I don't think it's precedent in any way, but that's the only time I've ever seen 7.3 is not a common allegation, yet you see attorney advertising all over the place. And again, my client's not the only one using these circulars and mailers or targeting people. That's a regular activity, whether it be criminal law, whether it be, I've seen it in medical malpractice for sure. In fact, that's probably another case that got to the board on a different issue on Marshall Lasser 2 decades ago. That was the issue. That case was ultimately dismissed at a hearing panel. There really is no guidance, and in this case should only be guidance back to the AGC, like, hey, you got to say that it has to be actually misleading and intended to mislead by the person who sends it. And they have neither of those things here.
I think that's one of my problems with the guidance on these letters. To me, we should have some form of guidance. I don't like the letter itself. That doesn't mean necessarily there's an ethical violation, as I've said. Hey, I'm old enough to remember when I first came into practice, the rule was no advertising whatsoever, as you probably remember. So anyhow, I'd like to hear back from the, go ahead. I'm sorry.
I'll mention it because it's interesting history. When Bates versus Arizona was decided, that's of course the landmark case in 1978 that allowed attorney advertising. There was a case called Jocks versus State Bar of Michigan, also pending in front of the Supreme Court, that was reversed. Instead of the writ being granted, it was reversed, remanded. And I believe the State Bar ended up paying money to Mr. Jocks, if I'm not mistaken. Always sat in the craw, I think, of Michael Allen Schwartz, God rest his soul. But it's not, every once in a while, these advertising cases, I guess, they come up, but they also go away, as they rightfully should, in circumstances like this, where, and by the way, there is some guidance, and it's in the form of an ethics opinion through the State Bar. I'm sure there are opinions on 7.3. And if you read those, they're going to say, at minimum, you probably have to have a disclaimer, which my client did.
That's good. Ms. Fleming, response on that one, please.
I would agree to the extent that from what I could find, I've been unable to find board opinions on point relative to the advertising. It's not an area that it's not an area that appears to be litigated very frequently relative to the advertising. I would also point out relative to Shapiro, the petitioner's brief does indicate that there are distinguishable circumstances. In this case, in that particular matter, there was no allegation that the letter was false or misleading. That's different than what the allegations that are being made here are. So that would be my response, Mr. Brown.
And I guess probably one of my problems is from the standpoint of the fact that you got a name, you got a letterhead. That's one of my problems. Again, I have a guidance concern about it too, based on Shapiro. So I just wanted to cover those questions.
Ms. Davidson, any questions? The panel?
Yes, actually for Ms. Fleming, so I'm having a look at the original petition here, and I just I want to understand your statement just now that there's no allegation that the letter was misleading.
In Shapiro.
In Shapiro, there was no, our position is that the statements in the letter here are false and misleading. In Shapiro, the Supreme Court says the commission there did not find that the letter was false or misleading. So in the briefing, we distinguish from Shapiro in that respect.
Okay, thank you for clarifying. Must have missed that. I have no other questions.
And I have no further questions. I don't know. Mr. Montgomery? I don't know if Owen.
Hi.
There he
Would
is.
you like to go into the breakout room?
We would. Thank you.
No problem. I'll open
And
that
thank you,
route right now.
counsel, very much.
Thank you.
Argument. Yes.
Okay.
All right, they went to the breakout room. It was like 20 minutes. And they're going to decide what's going on with the attorney that left out of court. And then he had a mailer where 600,000, that's how many, I guess, clients he has. One went out to a minor, and there was some things in there that made him think he had to look like he had to go to court or something, but he shouldn't have received a letter. So that's what the two issues are about. And that's why he's in this discipline hearing, because they want to decide on that.
Okay. The live stream will continue while the panel is in the breakout room, but hopefully it won't be too long for us. Okay. All right. The panel is prepared to continue this proceeding.
Okay.
I'm going to go ahead and close their breakout room, and they'll be rejoining us shortly. Okay. Looks like everything is set on my end. Ms. Papista, you may go back on the record whenever you're ready.
Great. All right. Hello, everyone. Well, the panel has met, and we are going to take this under advisement. If you two are able to work out anything in the meantime, let us know, and we will set a date for issuing our decision.
Thank you.
Thanks. Everybody have a great rest of the day.
Yeah.
Appreciate it.
Yeah.
Take care.
Thank you.
Yeah. Thank you.
Okay, that was it. We went from a fast-moving talking guy to a slow guy to this. Just wanted to bring something different to you. And now we're going to go out with our usual. Thank everyone that's been hanging out tonight. And let's enjoy the end of it. All right, let's go.
Check. Tri-County here in panel 16. Check. Case number 2590 gay. Yeah, they talking that courtroom drama. Listen. The motion got denied, yeah, the judge said no, but the attorney had another place he had to go. They call it misconduct, leaving after the jury's picked, but the defense says the rules are being loosely flipped. The regular scheduling issue, that's the claim on the floor. He didn't stick around, he headed straight for the door. The Court of Appeals said the judge was the one in the wrong, but the grievance admin is still singing the song. He missed the plea hearing, he left the client alone, while the defense is just chilling in the neutral zone.
It's the disappearing touch, a high-level escape, an attorney on the move, yeah, he's on a different tape. 600,000 letters, just a scrivener's mistake. They want to sanction greatness over something that was fake. Something that was fake.
600,000 mailers flying out of the shop. One hits a 16-year-old, then her heart starts to drop. potential criminal consequences. You going to jail for a failure to yield. Yeah, the system's gone frail. 1 error in a million, it's a statistical win. But the admin is calling it a disciplinary sin. The father's a lawyer. Yeah, that's the shocking twist. He didn't call his colleague, he put him on the list. The formal grievance filed for an automated glitch. Now we're arguing ethics in a legalistic pitch. Summary disposition, get it tossed, get it gone. The arguments are heavy and the hearing is long. Is it false and misleading or a data merge flaw? Just another Tuesday in the eyes of the law.
It's the disappearing touch, a high-level escape, an attorney on the move, yeah, he's on a different tape. 600,000 letters just to strengthen this mistake. They wanna sanction greatness over something that was fake. Over something that was fake.
Yeah. Fleming's at the mic and she's bringing the heat, saying the attorney story just doesn't meet the street. You can't blame the agency, you can't blame the clerk. The lawyer's got the license, he's gotta do the work. He didn't ask for permission, he didn't say goodbye. Just left the courtroom under a Michigan sky. Yeah, just 25.90 gay.
It's a disappearing touch.
Yeah.
It's a disappearing touch.
Yeah. We'll see what the board says. Session adjourned. Yeah.
Everybody have a good night or morning wherever you are. Thanks for hanging out tonight, and I'll see you again soon.